I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're joined in the studio by attorney Taa Grays, who is the new president of the New York State Bar Association, who's here to talk about her priorities leading the 150-year-old membership organization, as well as explore the significance of being the association's first black female leader. Well, being a state government show here, I'm primarily interested in your goals for Albany, whether it's legislation from the Capitol or maybe rules out of the judiciary. So are there any major issues or themes that you're hoping to lean into as the State Bar Association president?
So the mission of the New York State Bar Association is to be the leading voice for the legal profession by advancing three things. So the first is the professional success of our members. The second is equal access to justice. And the third is related to rule of law. So one of the areas I want to highlight is the family court. Many people who enter into family court are going there because they need help with resolving a problem. It's usually a very emotionally fraught time. There's tension between them and their partner. They're trying to make sure they're getting the right services or get the right type of resources for their children. Many people who go into the family court system don't have lawyers. They're not poor enough to qualify for free services. But it's not as if most people have rainy day funds for legal expenses. And so many of them, even if they may start off with a lawyer, if it goes longer, they run out of money. So they end up having to do it themselves. There are ways that I think the State Bar working with the courts can come up with some solutions. Now, there's not going to be a silver bullet to be able to address all the different issues, but bringing together our various committees and sections that work on these issues and working with the court's permanent committee on justice for families, I think we can come up with some really good solutions. Judge Wilson is focusing on this. He talked about it, I believe, in his State of the Judiciary earlier this year, that he wanted to focus on the family court. And this permanent commission that's focusing on justice for families is one aspect of that work. So I think bringing together his focus and those individuals within the unified court system and our members is a brain trust. We have experience, we have expertise, we have people who are creative and will be able to think outside the box to figure out how in the short term we can come up with some solutions, like low-hanging fruit, things that may be easy for us to address, figure out some of the medium-term solutions, and then there are going to be some longer-term issues, just kind of the nature of the way the system is going to be set up. That's just going to take time, but you got to start somewhere. And this is a group that's going to be able to say, okay, let's start somewhere, that we can make the experience for the litigants better, give them a better user end experience, which then makes it easier or a better experience for the attorneys and for the courts and the court personnel.
But when it comes to that dynamic you played out, where people don't have the funds to pay out of pocket for an attorney and aren't poor enough to access free help, it seems like the solution is the state or some other entity stepping in and funding attorneys. And short of that, are there other ways to incentivize people to get into this space or to make access more meaningful for people in that gap that we talked about?
So first, as it relates to the need for the attorneys in the family court system, yes, attorneys are needed, but there's some things that the parties don't need to go to an attorney in order to help them with, right? There are some resources that we can either create or are already available that people don't know about, sort of making sure they're following the appropriate documentation, going to mediation, going to negotiations. There are other types of services that they can go to before having to engage the court to resolve an issue. So I think there are things that we can create, but there are also resources that we can make people more aware of. Because people go, and it's a problem. How do we give people information so they don't have a problem, right? Or as they see the problem developing, oh, okay, well, I remember reading this thing about a resource in the court. Maybe it can help me to figure out how to address this without me having to go before a judge. So that's one aspect of it, about the need for lawyers. Make sure we're using lawyers where lawyers are needed and when parties need to pay for them. Another issue you're talking about is the distribution of lawyers more generally. It's expensive, and this is probably part of what you're asking about or is fueling your question. Law school is expensive. It's more expensive now than it was when I went to law school. And that does drive decisions. If you are going to be able to pay off your loans and live, it's just the basics. You're only going to probably look to certain types of jobs that are going to be able to support your standard of living. Are there things that can incentivize people to make decisions where they're not going into the private sector, but going into the public interest? Yes, there are some things like loan forgiveness. We've been an advocate of making sure that loan forgiveness programs are not changed in a way that prevents people from being able to take advantage of them. But there's also just making sure people are aware of opportunities that are available, like a program we have called Rural Ready that we've been working with the third department on, and Judge Elizabeth Gary, who's been the big advocate for it. Because sometimes people don't realize that there are opportunities where you can still pay your loans and do this work, but it may not be in the places where you think it is. But fundamentally, yes, trying to find ways of giving lawyers who want to do this work, who may not want to move to a different location, they may want to stay where they are. How do we help them to be able to afford to do the work as well as to afford to live? So rates for 18B need to keep up with inflation. They recently made some changes, which were great, but those rates have to be able to be consistent with inflation. As the price of goods go up, the price of services, the price to live, your salary has to also be commensurate with that. So there are some things that we can do in order to make sure that that's in place, because that's part of what drives people's decision making and what type of position and what type of roles they'll take as a lawyer.
Well, before we move on, let me reintroduce you. For listeners just joining us, I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're speaking with attorney Taa Grays, who's the new president of the New York State Bar Association. So one of the things that was highlighted in the announcement of your ascension was the idea of additional consumer protections in statute, and that's something that comes up repeatedly here in Albany, although we often get pushback from the business community, which says any sort of additional legal rights are going to add additional court costs, which translate into business costs. And I'm curious, how do you think about those arguments? For example, do you think there's some legitimacy to them, or do you feel like they're just trying to throw up obstacles to people who have maybe legitimate ways or legitimate concerns that need to be brought before the court system?
I worked in corporate America for 20 years.
So you know all the tricks and trades.
Well, I do appreciate the concerns that businesses are raising about regulation.
Mm-hmm.
And there are times that regulations can be onerous. But I also understand from the other perspective, because I used to work as a prosecutor, so I was in the public space. What regulators are looking to do is to protect constituents, protect consumers who don't have perfect information, right? This isn't what they do, whatever the business does. They don't do that from day to day. And so you need to have regulations to make sure that those interests are being protected. And you want to make sure that businesses are doing the right thing, but the regulation isn't so onerous that it prevents them from being able to effectively provide services at a cost that their consumers will be able to purchase. So I see both sides of the issue. One of the areas where I think this becomes clearer, and it's a place where I'm looking to provide some, hopefully, additional clarity and thought leadership on part of the Bar Association, is with terms and conditions. Many of us sign or check off the box on these terms and conditions because there's an app that we want, or there's a service that we want, or we want to access some aspect of a website. So we have to sign off on the terms and conditions. Most people just scroll through.
I am most people.
Yes, most people just scroll through. And do you really know what you're signing off on?
Usually waiving my right to bring some sort of case and agreeing to some sort of binding arbitration if it's Uber.
Yes, that's one thing.
Yeah.
But there are many other things, right, that are in there. So for the most part, people aren't fully aware of what they're signing off on just to get the new shiny tool. More often than not, it may not be an issue. But when it does become an issue, you have been checked off on a box saying that you understood what you agreed to. And yes, you may be going in for arbitration, or there may be other things that you've given up that you didn't even realize you gave up. Again, I understand from a business perspective why you do that. There are various regulations, and you want to make sure that as the business, you've given the information to the consumer. But it's a lot of information. Some of these terms and condition documents go on for 5, 6, 7, 10, 12 pages. Who has the time to read all that when you're trying to get the thing that you want? And usually you want the thing now, right? You're like, oh my gosh, I didn't realize I'd have to read this entirely long document.
In language that you might need a JD to be able to parse.
Yes. And that's another point. It's usually not written at the grade level that's recommended, which is usually around eighth grade level, maybe ninth grade level, so that it's accessible to everyone to read it, right? You don't want it to have jargon and terms that people just are just going to glaze over and not understand. So the goal of this initiative, our business law section is going to be working on this, is to find a way to create maybe some templates, give some guidelines on how to create a document that's easy for people to understand. And I've seen some other businesses do this. So you have maybe a top document that's more conversational, right? This is what this means. This is what that means. This is what you're giving up. This is what's going to happen next. If you have questions, please reach out to so and so. If you want more details about what's in this document, then you can click a link and then it gives you the 12, 13 pages, right? That has the more robust legal information. So it's doing things like that, or maybe we just come up with a document that we share. Most of these terms and conditions are generally very similar in what they are saying you give up and what things the company has to do and what things you have to do. So that we can probably provide maybe a document that goes out to various consumer groups, just educating them on what it is, what is in the terms and conditions, and what you're giving up, and what questions to ask. Unfortunately, from a business perspective, you can't have a consumer negotiating these terms. Too many people, right? So that's a challenge, but at least you can make sure people understand what it is that they're giving up or what they are agreeing to do is probably the best way of saying it. What the business is agreeing that they're going to do and what the consumer is agreeing that they're going to do and how we're going to move forward.
One of the tools that lawmakers often lean on to enforce some sort of consumer protection laws is this idea of a private right to action. And I'm curious what sort of significance you see in that type of tool as opposed to saying, okay, the Attorney General of New York is going to be responsible for ensuring compliance, and they're going to be the ones waving a stick around if things are out of compliance.
Yeah. From someone who's worked in corporate America for a number of years, a private right of action just creates a lot of uncertain litigation. Right? Don't know where it's going to come from, or it may come from plaintiffs' attorneys, right, who are looking to create class action lawsuits against a company for A, B, C, and D.
Some who may be your members now.
Some of them who are definitely my members, right? And there's a place for that, and there is a role for that, right? And the Attorney General has their role, right, in being the chief lawyer for the state and representing the interests of individuals when there's some sort of wrong or alleged wrong that has happened. I think you have to figure out what makes sense for the situation, right? If the Attorney General is really able to see the places where there could be problems and be the right lawyer to bring forth the issue, then maybe it should just be the Attorney General. It certainly creates a lot of clarity and more certainty for the business and businesses for knowing, okay, if something's going to happen, it's going to come from this particular person, right? We can understand that. We can wrap our arms around that. We can plan for that. Private right of action, that means there's a whole range of possible people who can sue us. Now we got to plan for that. We have to reserve for that. A little bit more challenging. But there may be needs to have both. Right. But I think it's going to depend on the particular type of regulation and the awareness of the Attorney General to be able to address the issues that possible litigants would have versus maybe they just don't have transparency into some of the ways that individuals are impacted. So you need to have a private right of action so that those individuals can make sure that their grievances or the way they've been harmed is also brought to the forefront. So again, the good attorney answer is it depends. It depends on the situation.
And after a quick break, we'll continue our conversation with Taa Grays, the new president of the New York State Bar Association. Support for the Capitol Press Room comes from O'Donnell & Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com. I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're continuing our conversation with former corporate attorney and Bronx prosecutor Taa Grays, who recently became the president of the New York State Bar Association. So, as I mentioned at the top, you are going to be, or are now, the first black woman to lead the New York State Bar Association, and I'm curious, what do you see as the significance of that, either symbolically or substantively?
From a substantive perspective, the New York State Bar Association has had a plan we have intentionally and thoughtfully worked to make sure we're creating an inclusive bar association. And I'm yet another culmination of that. And we had our first female president in like the 80s, and then we had our first black man, person of color president like in the early 90s, and then our first Asian American president. We've had 10 women. I'm the 10th woman as being president. The woman who's coming